First up, we're in Las Vegas, Nevada, where 27-year-old Jimmy Carter Kim is in court to determine his competency to stand trial. Kim pleaded not guilty to 83 felony charges, including kidnapping, sexual assault, battery, and lewdness with a child. The charges stem from two different incidents in which he allegedly drugged, kidnapped, and raped two underage teenage girls who he held captive in his bedroom.
Can I have a say?
Pardon me?
Can I have a say in this?
Well, I tried to give you a say, but you refused to talk to the doctor.
No, I spoke with the doctor.
Well, there was a second doctor, Dr. Paglini, you refused to speak to.
Under Nevada law, a defendant must undergo two independent psychological evaluations before a judge can make a ruling on competency. In Kim's first evaluation, he was found incompetent, but he refused to speak to a second doctor.
Mr. Kim, pursuant to Nevada law, NRS 178.415, I'm remanding you custody, transport to Lakes Crossing or Sinai Hospital for further observation.
I don't see what the relevance of me, why is my competency in question?
Because your lawyer challenged your competency or questioned it. I appreciate that you don't agree with Nevada law. I apologize that you don't agree with it. It doesn't really matter whether you agree with it or not.
What so far has been a respectful dialogue between judge and defendant is about to take a strange turn.
Well, can I ask you something? A young gentleman like me, young, charismatic, and fetching in these county blues, why would I be subjected to competency hearing or to an evaluation where I'm clearly cognizant of everything I'm doing? It's rubbish.
If only fetching were the standard, I'm not going to argue with you. In the meantime, you're going to Lakes or Stein. Thank you.
As officers escort Kim out of the courtroom, the Las Vegas local drops some choice British phrases.
State versus Eldrion Wilson.
After undergoing a second psychological evaluation, Kim is found competent. He entered a not guilty plea and is set to go to trial. Next, we're in Ann Arbor, Michigan for a plea hearing. 39-year-old Susanna Williams is pleading guilty to third-degree retail fraud. 3 months earlier, Williams, who has a criminal history, including possession of illegal substances, was in a supermarket when she ate some donuts without paying for them. She was arrested and originally charged with second-degree retail fraud. But when Williams failed to appear at her arraignment, a warrant was issued. When Williams finally did appear in court, she was given a bond of $1,000, but was unable to pay, so she's been in custody for 93 days. Today, Williams appears before Judge Cedric Simpson to enter her plea. She's represented by attorney Ron Brown, who has a long history appearing before Judge Simpson.
Your Honor, we're trying to resolve this case. I believe her jail credit is 93 days on this offense. So she would be seeking a credit for time served sentence with release. I believe the donuts that she stole and ate would be the basis for the restitution if the court were to order.
So there is restitution.
What's the restitution, sir?
You got to pay for the donuts you ate.
Oh, okay.
So do we know the amount of restitution?
I'm just double checking, Your Honor.
They weren't Dunkin' Donuts.
I believe that I do.
They were packaged donuts.
Okay.
Dunkin' are fancy. You know, you can get the ones with the sprinkles.
You want to know what?
And the nuts.
You know.
And the powdered sugar.
No, you know what?
They weren't those.
No, Mr. Brown.
They were just, they were
They
to
told
the
me,
package.
when they told me you were going to be here,
Right.
I almost stayed home.
For me,
Judge Simpson.
I like donuts. I should have brought you some. They go good with your coffee.
Meanwhile, the prosecution returns with the restitution fee.
$4.68.
Those are some pretty good donuts.
They weren't that good. Were they stale?
Yeah, I think so.
They were a little stale.
$4.68.
Yes, Your Honor.
You've been in since the time of the arraignment, is that correct?
for 93 days. Yes, Your Honor.
Court will accept the defendant's plea. Sentence of the court, fines and costs of $250. I'll order 93 days on this case. Credit 93 served. I will also order restitution in the amount of $4.68.
Including additional court costs of $50, Williams still owes the court a total of $304.68. But she's free to go, and the case is closed.
I am the living man whose mark is that of life.
Next, we're at the Gallatin County Courthouse in Bozeman, Montana.
The defendant, Ernie Wayne Tertelgit, he is not represented by counsel here today.
52-year-old Ernie Tertelgit is charged with obstructing a peace officer and resisting arrest after he was caught fishing without a license. The hearing is just underway.
Mr. Tertelgit has been charged with 2 misdemeanor offenses, which we'll be trying today.
I must object. I am not the name that he is referring to. I am the living man. The name that Mr. Riley refers to, ma'am, is held by the state in all capital letters and is identified by the state on the state's driver's license, ma'am. I am not the all capital fiction. I am the living man whose mark is that of life.
Tertelgit is representing himself today as the natural living man. It's his own interpretation of a sovereign citizen.
Mr. Tertelgit, you are not to interrupt Mr. Riley again.
Who can tell the living man
Mr. Tertelgit.
in a commercial event such as this,
Sir,
who has the right to tell the living man when he can speak and when he cannot speak, what sounds he can make and what sounds he cannot make?
you understand?
He is addressing British law, ma'am. He is a minister on behalf of Great Britain.
Great Britain? It seems this living man takes issue with the traditional British title of Esquire being used in an American courtroom.
I'm going to hold you in contempt if you continue to disrupt this.
Ma'am, why, please give me an honorable answer, is a British recognized Esquire asking questions in an American courtroom? Why is title of nobility applied behind this gentleman's name that is recognized as being banned from our country in the 1789 Constitution? Is nobody going to stand for our Constitution?
Tertelgit may not believe in courtroom formalities, but he does believe in interrupting. And Judge Wanda Drush has had enough.
Mr. Tertelgit, you'll be taken up to a jury room where we may watch the proceedings. I have reminded you twice now.
If I give you recognition.
Bob, please stand up.
All right.
Stand up.
No,
Stand up.
pick me up. I cannot give you recognition. I'm constrained by the United States Constitution of 1789.
Before he's escorted out, Tertelgit hurls a Yankee Doodle dandy of an insult at the prosecuting attorney.
Sir, you're a Bozeman native. What are you doing packing a British recognition? Should be ashamed of yourself.
Banned from participating, Tertelgit can only watch the courtroom remotely, as his case is finally able to continue. The jury would eventually find him guilty, and although jail time is waived, he's ordered to pay more than $400 in fines.
Would one of you remove my bolo tie and return it to somebody in the crowd, please?
Next, we're in Beaumont, Texas for a hearing. 31-year-old Arthur Washington has been charged with third-degree assault on a family or household member. 7 months earlier, Washington allegedly struck the mother of his children. He was arrested and released on $20,000 bond. And this was not Washington's first assault charge. 7 years earlier, he was convicted of a similar crime against the same victim. Today, Washington appears without a lawyer before Judge John Stevens to discuss next steps in the case.
You are charged here with the third-degree felony of assault family violence, which carries with it up to 10 years in prison if convicted. Are you getting a lawyer?
Yes.
Who?
I don't know.
So you don't have a lawyer yet?
No, I was on quarantine. Man, I was able to work.
You're on quarantine for what?
Tuberculosis.
So why the hell are you here in court if you're in quarantine for tuberculosis?
Not supposed to come to court.
What did your doctor say about this?
On quarantine.
What does that mean to you?
Not to go longer.
But you're here, so you disobeyed your doctor's order. Why don't you even have a mask if you've got tuberculosis, sir? Sit over there. Sit over there, right over there. You're in quarantine. You're quarantined over there. That's terrible. You don't have any common sense to do better than that?
After placing Washington in the jury box, Judge Stevens moves on to his case.
This case involves an who is that?
That's the mother of my children.
You know you can't have any contact with her.
Yeah.
Do you have a GPS device
Yes.
on you?
Yes.
Let me see it.
My phone? This is the only thing I have GPS on?
That's not, no. It's supposed to be attached to you.
Oh, no. I don't have it.
Yeah, you do. That's
Oh.
ordered. And I just ordered it.
Okay, right now.
When the court orders, like it orders in every case like this, a GPS device, you have to have it on your person. So we know where you are at all times. You have 48 hours to do that. And I want to see a receipt of it, or else I'll issue a warrant for your arrest. Do you understand?
Yes.
As ordered, Washington purchased a GPS tether, and he remains free on bond. His case is pending. Next, we head to Atlanta, Georgia for an arraignment. Rodney Thomas has been charged with criminal trespass. A day earlier, Thomas, who has previous convictions for aggravated assault, battery, and drug possession, was arrested for urinating in public at a MARTA train station. Today, he appears before Judge Jesse Lall to hear if he'll be offered bond. The state is represented by Ginta Bickerstaff, who's recommending a $3,000 signature bond through pretrial services. Jay Kim, the public defender, agrees with the bond, but prefers that it goes through a jail diversion program called PAD, where community workers help people who've been arrested avoid incarceration. Bickerstaff strongly disagrees with that option.
Your Honor, the state's recommendation to have his bond through pretrial seems more reasonable considering that this defendant just pled guilty to a battery charge and he's currently on probation for that case as well.
Okay. Bond is set at $3,000. It's going to be a signature bond through the jail.
Judge Lall rules to allow Thomas to stick with the PAD program, and the hearing's essentially over. But it looks like Thomas wants to say something.
Mr. Thomas,
Yes, ma'am.
why are you putting your hand up? And do you have something to tell me?
Yes, ma'am.
Please do not say anything. You got the best signature bond through the jail, please. You have nothing to say.
Despite his attorney's advice, Thomas seems determined to make a statement.
I just wanted to state that I am not on probation. That case was closed.
Okay, you don't have to talk about anything else.
Mr. Thomas, you have 77 arrest cycles. Do you think I really care whether you're on probation or not?
No, ma'am.
Then why would you mention it?
Yes.
The only reason I'm granting a signature bond is because it's being recommended by the prosecutor. But I was looking at a $5,000 bond because apparently you do not know how to use a bathroom. Do you understand, sir?
Yes, ma'am. I'll do better, ma'am.
Very good. You are to stay 200 yards away from each and every MARTA station or property, including their sidewalks and their parking lots. Do you understand?
Yes, ma'am. I know.
And if you need to answer nature's call, do you know what that means?
Yes, ma'am.
You are to use a proper public restroom or the privacy of your own restroom. You are not to exhibit yourself in any kind of public way in order to relieve yourself. Otherwise, the state's it has its right to charge you with public indecency. Do you understand, sir?
Yes, ma'am. I do.
All right. I can't believe I'm telling a grown man how to use a bathroom. This is all shame on you.
Yes, ma'am.
Thank you.
Thomas was released on bond, but must continue his diversion program until his next court date. His case is pending. Next, we're in Ann Arbor, Michigan for a plea hearing. 24-year-old Joshua Sawyer has been charged with aggravated stalking, assault, unlawful imprisonment, 2 counts of aggravated domestic violence, and other charges. 2 months earlier, Sawyer allegedly assaulted his ex-girlfriend 2 separate times. He was arrested and held without bond. Today, he appears from the county jail before Judge Ariane Slay. He's represented by attorney Jinan Ahmoud.
How are we proceeding today?
Anna, at this time, we met with you in chambers prior to today, and I submitted a COPS request on behalf of Mr. Sawyer. You have indicated that you would not be inclined to commit to the COPS request, so I would like to adjourn this to allow me time to decide how we want to proceed.
But before the judge can respond to Ahmoud's request for an adjournment, the defendant has something else he wants to discuss.
Can I speak on my phone situation? The arraignment judge that took my phone, like at the beginning of this,
Mr. Sawyer, whatever you want to address with the court, I think it's best if you do it through me, okay?
No, I gotta get my phone back. I can't contact my people. I haven't been able to get in contact with my family, none of that. So I was like, wanted to ask the judge, like, can I get my phone back in here? I don't have my phone. I have no way to contact nobody to the outside world. I got family that don't even know I'm in here. So I'm trying to like have a way to contact the outside world. My phone been taken for 2 months. I never had like a paper to say why they took it.
Mr. Sawyer, are you asking for your phone to be able to use it while you're in jail, or do you just need the phone numbers off your phone?
No, I need to use the phone while I'm in jail. I haven't had no contact with my people, with my family since I've been in jail.
Judge Slay decides she needs to step in.
Mr. Sawyer, if your request is that your phone be removed from property to get certain information off it, to get the phone numbers, that's something Ms. Hamoud will have to work out with the prosecutor's office.
No. I'm talking about my phone account. I haven't even been able to call my people since I've been here. Like my phone account been took. I haven't been able to contact nobody. Family don't even know I'm in here.
Talking about maybe Mr. Hamoud's.
I think he wants his cell phone. It's his account.
He's talking about his jail phone.
My jail phone.
A fellow inmate attempts to help clear things up, but it only seems to add to the confusion.
I don't have any control over the jail phone, so I'll let you and Ms. Hamoud figure out what you need to do.
Judge, I'm saying. Judge, if you grant my phone, if you tell them that they gotta cut my phone back on, they're gonna cut my phone back on. I have no contact with my family or nothing since I've been in here. This is crazy.
As the hearing comes to an end, Sawyer becomes even more frustrated.
Like this got to be against some type of law or something. Like I need my phone, like to contact my family.
Mr. Sawyer, please, can you please?
I can't even.
Just let us meet, and we'll figure it out, okay?
So what am I supposed to do until then? Until we meet, to get my phone and contact my people.
Mr. Sawyer.
Mrs. Slade, what's up? I need my phone.
What's up? I'm gonna tell you what's up.
Tell me what's up.
What's up today? We are handling your adjournment, your phone,
I need my
and
phone
your
to contact my people. That's against my constitutional rights. That's against my constitutional rights. That's against my constitutional rights. I need my phone.
No problem.
Judge Slay seems to have had enough. She quickly mutes the defendant and ends the hearing. Sawyer later pled no contest to aggravated stalking, aggravated domestic violence, assault, and electronic communication causing injury. The other charges were dropped. In total, he received a sentence of 67 months to 10 years in prison. Next, we head to Newfane, Vermont for a trial. 50-year-old Christopher Knutson has been charged with reckless endangerment and 7 counts of violating an abuse prevention order. 2 years earlier, state police served Knutson with a restraining order prohibiting him from contacting his wife or their 2 children. It also required him to turn over any guns in his possession. But police say Knutson refused to cooperate. Instead, he barricaded himself in his home, leading to a 5-day standoff. With police outside, Knutson then allegedly violated the protective order by texting his wife several times. He also called 911.
Where's my emergency?
Yes.
All right,
our emergency's right here.
Okay, what's going on?
I gotta vacate the premises immediately and hand over my gun.
Okay.
Or nobody's seen in the house unless it's in a body bag.
After tear gas was deployed, Knutson finally surrendered. Once inside, police say they discovered several guns. Knutson was arrested and held on $50,000 bail. He pled not guilty, and after a psychological examination, was deemed competent to stand trial.
Please be seated, everyone.
Knutson, who often refers to himself as Christ, is represented by a public defender. From the outset, he's disruptive towards the court.
This is a kangaroo proceeding. You know it and I know it.
Mr. Knutson.
What you're doing is unlawful.
Is disruptive of this proceeding. Mr. Knutson will be removed from the courtroom. We will continue with the proceeding with Mr. Knutson's absence.
It's all unlawful. It's a violation of my human rights.
Today, after Knutson is removed from the courtroom several times by Judge John Treadwell, he's questioned about whether he identifies as a sovereign citizen.
I've never identified myself as a sovereign citizen. In fact, the definition of a citizen is a person, and the definition of a person is a fictional entity. So to call me a sovereign fictional entity, to me, that doesn't even make any sense. So the answer is no, I'm absolutely not a sovereign citizen. I'm just simply opposed to fraud and deception.
Prosecutor Dana Nevins then asks about Knutson's standoff with police.
Some deputies come to your house.
They did.
And did they give you a copy of this document?
Who am I?
I'm asking if did you get a copy of this document?
Who am I?
I just am wondering if you got a copy of this document.
I'm confused.
I'm gonna just refer to you as you. I won't refer to you as anyone else.
That doesn't work for me.
Okay, how should I refer to you?
I am a human being, and a human being is a flesh and blood soul.
Okay. You sent various text messages at different point in time to starting on September 2nd. Is that correct?
Are we talking about Christopher Knutson?
I'm asking if the person, the flesh and blood soul in that chair.
Is the flesh and blood soul a person?
I don't know.
You can't come up and tell me who I am, what I am. Because where does it end? It's never going to end. Everybody's on autopilot. And if anybody asks any questions, bam, don't you do that. See, that's why I've been in a jail cell for the last 2 years.
Members of the jury, we're going to take a break.
The trial lasted 3 days, and after deliberating for 2.5 hours, the jury found Knutson guilty of reckless endangerment and violating an abuse prevention order. He was sentenced to a total of 38 to 48 months in prison with 2 years credit for time served.